Good afternoon. The court is going to take up the next case on the court's docket. This is cause number C210042CPS. This is in the interest of Serenity Resendez and Jessica Funk. The case has been reset from an earlier setting on July 6, 2021 to today's date for a status hearing to resume. The court would also take judicial notice of the court's file to the extent the case is also set for a hearing on a motion to withdraw filed by Tom Davidson seeking to withdraw as attorney ad litem for the respondent, Father Craig James Funk. The hearings today are being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the hearing today on behalf of the department is caseworker Mandy Williams, Supervisor Isabella Reyes, and Regional Attorney Catherine Estrada. The mother of the children is Esperanza Resendez, and she is participating in the hearing today with her attorney, Todd Simons. The father of the two children is Craig James Funk, and I believe he is participating in the hearing today. I'll confirm that in just a moment, along with his attorney ad litem, Tom Davidson. Gonzalo Rios is not present due to a schedule conflict, but he has filed a report with the court reflecting his position as attorney and guardian ad litem for the children. I believe the current caregivers for the children are Carmen and Raymond Resendez, who are maternal grandparents of the children, and they are not currently participating in today's hearing, and the court has excused from participating in the hearing today the two children that are the subject of this suit. As I indicated, there's two different matters set today. There's a resumption of the status hearing, and there's also a hearing on a motion to withdraw filed by Mr. Davidson. I believe I'll take up the motion to withdraw first before proceeding with any resumption of the status hearing. Let me confirm that Mr. Funk is on our conference and able to hear us. Mr. Funk, are you able to hear us, please?
Yes, sir, I am.
Okay, thank you. All right, if we're ready to proceed, Mr. Davidson, do you want to speak to your motion, and then I'll take that up first. Thank you.
Yes, Your Honor. We had previously had a status hearing on this case. And Mr. Funk and I talked about the fact that I got into the case a little late and was trying to get up to speed on it. He filed a document with the court in which he called me a liar, that I had had paperwork since June 27th, and that my stating that I was late getting into the case was a lie. I will not represent somebody who does not come and discuss those things with me. If there is some kind of misconfusion or stuff, somebody who calls me a liar in official proceeding to the court, no, I'm not going to represent him. Additionally, I was trying to get him in or to talk about his case. He wouldn't talk to me over the phone. I was trying to get him in to sit down and talk to me, and he wouldn't come to the office. So he needs an attorney who can represent him fully, and that's not me.
Thank you. Mr. Funk, I'm going to need you to raise your right hand, please. Do you solemnly swear or affirm any testimony you give today before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Funk, as I indicated, the first matter that the court's taking up today is the motion to withdraw that Mr. Davidson has filed. In that motion, he is seeking to withdraw as your court-appointed attorney ad litem in the case. Are you in agreement with that motion to withdraw? Are you opposed to that?
No, absolutely.
Okay, well, absolutely you're in agreement, or absolutely opposed?
I'm in agreement with that as well.
Well, you understand if I grant his motion to withdraw, he'll be discharged as your attorney ad litem. And at that point, you'll either need to retain an attorney or establish that you still would qualify for a court-appointed attorney in the case if the court if you're requesting a court-appointed attorney, the court would have to determine whether or not you still are unable to hire one on your own. If you are determined to be indigent, the court would appoint another attorney for you in the case. So you understand that's the way we're going to need to proceed if I grant this motion of withdrawal.
Yes, sir. Does that mean I need to go to the courthouse and do some paperwork or
Well,
what?
I'm going to take some additional, if you're going to request a new court-appointed lawyer, I'm going to take evidence from you to determine whether you qualify for that appointment. If you qualify for a court-appointed attorney, then the court would appoint an attorney to substitute in place of Mr. Davidson in this case. Now, if you desire to retain your own lawyer, you would certainly have the right to retain your own counsel. You also have the right, if you don't want a lawyer, to represent yourself. But I'll need to determine how you want to proceed on that. But my understanding as it relates to Mr. Davidson is you're consenting to his motion to withdraw. Is that right?
Yes, sir.
Okay. All right, Mr. Davidson, I'm going to find good cause to discharge you as attorney ad litem for Mr. Punk, and you are discharged effective immediately, and you are free to leave the virtual courtroom should you wish to do so.
Thank you, Your Honor.
Thank you. All right, Mr. Funk, regarding the issue of legal representation of yourself, are you desiring time to try to retain a lawyer to represent you, or are you requesting the court appoint an attorney ad litem for you?
Yes, I'd like the court to appoint an attorney for me.
All right, and you are the father of the children Serenity and Jessica that are the subject of this suit, right?
Yes, sir.
Do you have any other children under the age of 18 other than these two children?
No, sir.
Are you currently employed?
Yes, sir.
Okay, where are you employed at?
Buddy's fertilizer plant in Ballinger.
All right, and is that a full-time position or part-time position?
It's full-time, sir.
Okay, and are you paid by the hour or a salary?
By the hour, sir.
Okay, and what are you paid per hour?
$12.75.
And are you paid weekly, bi-weekly, monthly?
It's weekly.
Weekly. Okay. And what is your average take-home pay, the net after you have all the deductions taken out?
It's roughly about $400 a week.
All right. And in addition to that income, do you have any other source of income other than from that job?
No, sir.
Do you have any assets of any significant value?
No, sir.
All right. Stand by for just a second. Are you receiving any type of governmental assistance at this time?
No, sir.
Well, I'm going to find that you qualify for a court-appointed lawyer based on the testimony as to your income at this time. I'm going to enter an order appointing another attorney ad litem for you. I do want to be clear, however, that you have a duty to cooperate with your lawyer. I'm not trying to quibble with you whether you did or didn't cooperate with Mr. Davidson relating to the case, but I will caution you that if I receive a second motion to withdraw from the attorney appointed for you in this case as it goes forward, and they are indicating that you're not cooperating with that representation, then the court could potentially find good cause in connection with that a second motion to withdraw to not appoint further counsel for you should the court grant that motion to withdraw and discharge your second attorney ad litem. So I'd encourage you to cooperate with your attorney as this case goes forward. Again, I'm not saying you did or didn't at this point. I'm not making a finding on that, but you need to work with them so they can represent you as the case proceeds. I'm going to appoint Jeff Beatty as your attorney ad litem. He's an attorney here in Tom Green County, and he'll be notified of that appointment. You'll need to confer with him regarding your position in the case.
Okay. Can I ask if you can repeat his last name for me? It was Jeff what?
Jeff Beatty, Betty. And it'll
Okay.
take a little while before he'll get notified of that appointment. So, but once he's notified, you'll need to get with him and confer with him regarding your position in the case.
Okay.
The second part of what was set for hearing today is the status hearing. The status hearing, primary purpose of that is to determine whether or not to approve the family service plans prepared by the department for you and Mrs. Resendez. The law requires the department to prepare those service plans to outline services or tasks that the department proposes to offer to the parents to try to address whatever the concerns were that prompted them to file this suit, with the goal of trying to work with the parents to resolve those issues so that the children can be returned to the care of the parent. In reviewing the file, it appears that you have reviewed that service plan, and at least according to the documents in the file, you've signed that service plan at this point. Is that correct, sir?
Yes, sir, it is.
Okay, and did you have any objections to that service plan at this time?
No, sir. No, sir. I plan on doing everything to the fullest.
All right. The service plans are reviewed during the course of the case. Sometimes they are changed, and if issues develop as we go forward, you can raise that at subsequent hearings. Mr. Simons, my understanding from my notes is that at the last hearing, your client, Mrs. Resendez, had indicated she didn't have any objection to the service plans. Is that correct?
I believe that's correct.
Okay. All right. Thank you. All right. Well, the court will, as for purposes of the status hearing, find these service plans to be reasonable and appropriate. I'm going to approve them and make them orders of the court. The department is ordered to provide services as outlined in the service plans, and the parents are ordered to participate in those services as outlined in those plans. Court will continue the department as temporary managing conservator and continue the children in their current placement. The next hearing in the case right now is set for November 8, 2021 at 10 a.m. That's an initial permanency hearing. The permanency hearing and pretrial is set for March 8, 2022 at 10:30. A trial, if needed, is set for April 15, 2022 at 10. And the dismissal date for the case is May 16, 2022. I'm required to notify any parent in this type of case that because of the nature of these proceedings, your parental custodial rights and duties to your children may be subject to restriction or even termination in your progress under any court orders, and the plans of service approved by the court will be reviewed at future hearings in this case. I would encourage each of you to try to cooperate with the department to resolve any concerns they may have, and hopefully the children can be returned to your care. With that, we'll be adjourned for